What you're about to see is not just a political debate, it's a battle over what the public is allowed to know. In a government that promises transparency, there are vaults of information that remain sealed, and the reasons why are often more revealing than the secrets themselves. This raises a critical question. When an official cites the law as a reason for secrecy, are they upholding justice, or are they using it as a shield to hide an uncomfortable truth?
Gentleman from New York is recognized. Mr. Goldman.
Mr. Patel, does Donald Trump appear anywhere in the Epstein files?
I'm sorry, could you say that again?
It's not a complicated question. Does Donald Trump appear anywhere in the Epstein files?
I didn't say it was a complicated question. I just didn't hear you, so my apologies. We have released where President Trump's name's in the Epstein files and everybody else, and all credible information that we are legally allowed to release has been released.
All right, so let's go through that. You're referring to court orders that prohibit you from releasing grand jury testimony under Rule 6E. Is that what you're referring to when you say as the law allows?
That's a piece of it.
Really? What other evidence do those three court orders you cited prohibit from being released?
Information that was collected pursuant to those search warrants that were limited
Wrong.
in fashion.
Wrong. That's not what the court order says, and that's not under 6E.
And you're talking, and I said that's 6E, and I said there was others, and I'm answering that. There are sealed court order documents. There are protective orders. From
they are unsealed as part of discovery given to Ghislaine Maxwell. They are no longer sealed.
That's just not true. We can argue about it all you want.
Okay, well, you agree that there are, so your testimony here is that the reason why you are not releasing all of the videos that you have acknowledged, there are so many, and that the FBI spent thousands of hours of reviewing, the photographs, the photographs that you have. You're saying that you're not releasing those because there's a court order requiring them to be sealed? Is that your testimony?
Never said that about the videos. On the totality of the videos, of the thousands of images that were seized pursuant to the search warrants executed at the time, the overwhelming majority of that video is pornographic material that was downloaded from the internet and child sexual abuse material. We will never release that.
Well, as you should not release the victims, but if there are videos that relate to others who Epstein trafficked to, such as maybe Prince Andrew, or photographs, that you have total control to release.
Yes, and if it exists.
And so why haven't you released it?
Why are you supposing that that is a fact when in fact it is false? Are you saying that
you're saying that none of the videos relate to anything relevant to the Jeffrey Epstein trafficking ring?
Every single video that we have collected pursuant to the prior search warrants has been examined for the last 10 years. And every single video has been utilized for whatever prosecutions were able to be legally brought.
I'm not asking about prosecutions. I'm asking about why you aren't releasing the full Epstein files, including the names of people who were involved in the sex ring that you promised to do before you became FBI director.
I just told you, I'm not going to release downloaded porn of children on the internet.
I'm not asking about that. Fine. I'm asking about all the other files.
What other videos? Tell me. Tell me.
That's what I'm asking.
Tell me.
You're saying there are no videos that would be relevant to anyone else involved in the Jeffrey Epstein sex ring.
Pursuant to Mr. Acosta's collection of information based on the search warrants. That's all we have in our possession.
And I'm asking you, that stuff.
That's all we got.
I'm not asking all you got. I'm asking you, in that stuff, there's nothing that's related to any other sex traffic, any other people engaged with Epstein in underage sex.
That's correct. To my knowledge, no.
Okay. Let's talk about the witness interviews. 302s of witness interviews. Those are not subject to the court order. Those are not subject to any fictional sealed order for a search warrant. Why aren't you releasing those with the redacted names of the victims?
We are releasing as much as legally allowed. That's why we went back to the courts.
How is that not legally allowed?
Sir, do you know how court orders work? Do you know how protective orders work?
Actually, Mr. Patel, I was a real prosecutor for 10 years. I know exactly how.
So I was a fake one?
And I want to understand what the court order prevents you from releasing witness statements that the FBI took.
You should know that as a real prosecutor, when the court hand downs a protective order and a motion to seal, the material is sealed unless that judge waives it.
Your testimony here is that all of those witness statements are under a court order, a protective order.
We are providing everything we can legally provide.
No, that's not my question.
Congress has sent this
My
subpoena.
question is, why are those witness statements that are not grand jury testimony, that if they were under a protective order are no longer under a protective order, why are they not being released?
How are they not under a protective
Why
order?
are you not going to the court like you did for the grand jury testimony to unseal those
The
records?
DOJ did go to the court.
No, not on those records. Why
Time
aren't
of
you
the
going? You
gentleman.
just went on grand jury.
Time of the gentleman has expired.
You are hiding the Epstein files,
Time
Mr.
of the
Patel.
gentleman has expired.
This wasn't a simple Q&A session. It was a strategic takedown. The questioner, Congressman Goldman, is a former federal prosecutor, and he uses that experience to dismantle the argument of the official, Mr. Patel. Goldman's strategy is clear. He starts with a simple, direct question about a specific name to set a baseline. When Patel evades, citing legal prohibitions, Goldman doesn't just accept it. He dissects that justification piece by piece. He isn't just asking questions. He's demonstrating that Patel's legal shield has holes in it. Notice how Patel's answers are consistently broad. He repeatedly says, they've released everything they are legally allowed to. But Goldman knows this is a vague defense. He presses on the specifics. What about the witness interviews? The so-called 302 seconds. This is a crucial point. While grand jury testimony, protected under Rule 6E, is highly secret, standard witness interviews conducted by the FBI are not automatically sealed forever. Goldman's point is that if these documents were sealed under a temporary protective order for a trial that is now over, there is no legal reason not to release them, with redactions to protect victims. Patel's inability to give a clear legal reason for withholding these specific documents is the entire point. His defensiveness, especially when he questions Goldman's credentials, suggests he has been backed into a corner. The three key themes Goldman hammers home are: first, a broken promise of full transparency; second, the deliberate mixing of legally protected material with material that could be released; and third, the strong implication of an active cover-up. This exchange goes far beyond the Epstein case. It touches on a fundamental tension in any democracy: the balance between secrecy and the public's right to know. Governments often justify withholding information by citing national security, ongoing investigations, or the privacy of individuals. While often legitimate, these reasons can also be used as a blanket excuse to avoid accountability. Think of it like a company refusing to release internal reports on a dangerous product by claiming they contain proprietary trade secrets. The excuse might be technically true, but it conveniently hides information the public desperately needs. In this hearing, Patel's argument that he cannot release videos because they contain illegal child abuse material is a perfect example. Goldman immediately agrees that such material should never be released. His actual target is the other evidence, videos, photos, or documents related to the powerful individuals involved in the trafficking ring, which Patel seems to be lumping under the same justification for secrecy. This creates the appearance of protecting victims while potentially shielding perpetrators. So, what are the key takeaways from all of this? First, the core of the disagreement is not about releasing illegal or sensitive material related to victims. It's about all the other files that don't fall under those protections. Second, the questioner systematically exposed that the official's broad legal justification for secrecy may not be as solid as he claims, especially regarding witness interviews. And finally, the official's evasive and defensive responses, rather than clarifying the situation, only fueled the suspicion that information is being deliberately withheld from the public. This leaves us with a critical question. Is this a case of an official carefully following complex legal orders to the letter? Or is it a calculated effort to use those same laws as a cover to bury the full story? What do you think? Let us know in the comments below. And if you found this analysis helpful, be sure to like, subscribe, and share this video.